Breaking news, Nigerians. Nnamdi Kanu files objection challenging Nigerian court jurisdiction to try him. Kanu filed the notice of preliminary objection on the strength of sections 1, 6, 12, 36, 8, 36 in brackets, 42, 45, and 251. 1 in brackets, Q in brackets of the Constitution of the Federal Republic of Nigeria, 1999 as amended. Hello everyone, welcome back to Prospect Channel TV. Thank you for always coming out here. If you are just joining us, please kindly subscribe to this channel. Don't forget to give us a thumbs up. Thank you. The detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has filed a preliminary objection before the Federal High Court, sitting in Abuja, challenging the court jurisdiction to try him. Kanu, in the notice of preliminary objection to jurisdiction of the court, filed on Monday through his legal team, led by his special counsel, Barrister Loy Ejimako, told the court that it has no jurisdiction to try him, stressing that charges filed against him before the court by the Nigerian government are all constitutional. Kanu filed the notice of preliminary objection on the strength of sections 1, 6, 12, 36, 2, 8, 32, 45, and 251 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Section 178 of the Customs and Exercise Management Act as reappealed. Section 218, 1 and 2, and 220 of the Administration of Criminal Justice Act, 2015. The Terrorism Prevention Amendment Act, 2013, as reappealed and under the inherent jurisdiction of the court. He said that the court has no jurisdiction to try him on counts 1, 2, 4, 5, and 8 on the points and authorities to the extent that the provisions of the Terrorism Prevention and Amendment Act 2013, TPAA, enabled the Nigerian government to determine questions arising in the administration of TPAA, which led to the ex parte order of persecution of IPOB and its declaration as a terrorist group, and the gazetting of such under without giving the applicant an opportunity to make representations to the authorities, is void for being inconsistent with the provisions of Section 36 of 36, 2 in brackets of Constitution of the Federal Republic of Nigeria, 1999 as amended. CFRN or on the Constitution. The legal team said that Section 36 of the Constitution provides, without prejudice to the foregoing provisions of this section, a law should not be invalidated by reason only that it confers on any government authority power to determine questions arising in the administration of a law that affects or may affect the civil rights and obligations of any person if such law. 1. It provides for an opportunity for the persons whose rights and obligations may be affected to make representations to the administering authority before that authority makes the decision affecting that person. 2. It contains no provision making the determination of the administering authority final and conclusive. The IPOB leader prayed the court for an order of this honorable court declining jurisdiction to entertain court count 1, 2, 3, 4, 5, and 8 of the charges against the defendant or applicant, or to quash said court on the ground that the law upon which said counts are predicated is unconstitutional, and law under which applicant is being tried in this count has otherwise been reappealed. An order of this honorable court declining jurisdiction to entertain count 3 of the charges against the defendant, or to quash said the court on the ground that the said court is unconstitutional. It is not supported by proof of evidence and is otherwise an abuse of the process. An order of this honorable court declining jurisdiction to entertain court count 1, 2, 4, 5, and 8 of the charges against the defendant, or to quash said court on the ground that of the failure to state the place of commission of the challenge offences and the specific date of the broadcasts alleged. An order of the Honorable Court declining jurisdiction to entertain count 15 of the charges, or to quash said court on the ground that the said count is not in compliance with the Administration of Criminal Justice Act, is not within the territorial jurisdiction of this honorable court, and is not supported by any proof of evidence, and no law under which applicant is being tried in this count has otherwise been reappealed. So guys, you've all heard it now. Mazi Nnamdi Kanu, as you can see, he thinks he's not ready to give up yet. You understand? He's still fighting very hard on this. This is what you get when you have issue with somebody who is really very conversant with the law and everything. So we are watching to see what is going to be the next action of the federal government of Nigeria, though the court case has been fixed, on July as well. I'm dropping it here, guys. Kindly drop your comment below the comment section. Don't forget to give us a thumbs up. Thank you.